Honor. It looked like you need Officer Tate.
We are looking for Officer Tate.
Okay. Give me 1 second. Let me give him a call. Okay. Here on duty.
Okay. Okay. You can turn your camera off and audio off while you do that.
Yes, sir.
So, Miss Jefferson, definitely not Miss Ferguson. Officer Lamb may save you on those two other warrants. For the record, I'm calling the case State of Georgia versus Justin Harris. Mr. Harris is charged in warrant number 2022 CW 52294 with committing the offense of sexual battery. He's also charged in warrant number 2022 WA 08116 with committing the offense of sexual battery. And finally, he's charged in warrant number 2022 CW 52316 with committing the offense of sexual battery. Mr. Little is here. Mr. Harris is here. He's represented by Mr. Little. Miss Jefferson, definitely not Miss Ferguson, is here representing the state. And I have to say that, Miss Jefferson, just so I don't screw it up or mess it up again. So for warrant number 2022 WA 08116, the arresting officer is an Officer Wynn who's present. We don't have Mr. Tate present here, but for the moment, we're going to proceed on this case with Officer Wynn. So, Ms. Jefferson, you can swear your witness in and begin your examination.
Officer Wynn, can you raise your right hand, please? Do you swear or affirm the testimony that you are about to give in these proceedings is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. You can lower your hand. And if you could state your name and where you are employed.
My name is Officer Wynn. I work at the Mara Police Department.
And were you so employed there on May 14th, 2022?
Yes, ma'am, that's correct.
And on that day, were you dispatched to the Walmart on 6065 Jonesboro Road in Monroe, Georgia in Clayton County?
Yes, ma'am.
And can you tell us why or the basis for the warrant charging Mr. Harris with sexual battery? What are the facts or the information that you obtained in your investigation to justify that sexual battery warrant?
Yes, ma'am. On the above date, I was dispatched to Walmart in reference to a suspicious person. Upon arrival, I met with the asset protection officers. The officer stated that there were a black male subject walking around spraying lotions on women, and the officer later notified me that he was in the grocery section. I went to the grocery section, and that's where we detained him. And after we detained him, they through security surveillance footage, I noticed Mr. Harris grabbing a bottle of lotion from his left pocket, and one of the female subject was bent over, grabbing an item from the shelves, and he proceeded to spray the lotion on her buttocks and recorded it with his phone. And that's it, ma'am.
You said that he retrieved a spray bottle of lotion?
Yes, ma'am, a bottle of lotion, and he proceeded to spray it on her butt while recording it.
And the individual that he did this to, did you speak to her or get her name, or did someone speak to her?
Yes, ma'am. We had a witness statement form filled out that she filled out, ma'am.
I'm sorry, your phone is blinking in and out. I didn't hear all of that.
Oh, yes, ma'am. I said that I had her fill out a statement form.
Okay. In her statement form, the lotion being sprayed on her body.
Yes, ma'am.
And the recording that you say was made on
Miss-
Mr. Harris's phone.
Miss Jefferson, I'm sorry.
Wait a
I'm
minute.
gonna stop you for a second because you kind of faded out a little bit, and I didn't know if you paused or if you had said anything. So if you paused and didn't say anything, that's fine. But if you said something between his answer and your response, I need you to restate it.
Sure. You said that there was a recording of the spraying on the victims, but on Mr. Harris's phone. Did you say that?
I'm not sure if if there's a recording, but when I looked at the surveillance footage, he was hovering his phone over her butt while he was spraying the lotion on her.
Understood. That's all I have.
Yes, ma'am.
Mr. Little?
Thank you, Your Honor. Officer Wynn, did you make contact with the alleged victim in this case?
Yes, sir.
That was a Miss Bailey.
Yes, sir.
Okay. Now, Miss Bailey, did she tell you that she didn't realize that anything had been squirted on her?
Yeah, she noted that she noticed Mr. Harris following her around, but she was unaware that anything was sprayed on her, sir.
Were you able to see if anything was sprayed on her? Was there?
Yes, there was surveillance footage from Walmart security camera.
I mean, like on her clothing. Was there evidence that the clothing had been sprayed?
I didn't notice any. Well, I didn't even look, sir, so I didn't notice.
Okay. So your witnessing of this would have been through the surveillance footage from the Walmart.
Yes, sir, that's correct.
Okay. Now there was also an allegation that Mr. Harris was, I guess, filming this himself.
Yes, sir.
Okay. And this was inside of the Walmart.
Yes, sir, that's correct.
Is the building open to the public?
Yes, sir, I would say.
Okay. And while people are in the Walmart, they're being filmed by Walmart itself, right?
Yes, sir, that's correct.
So everybody who's in the Walmart is already being filmed.
Yes, sir.
So it's not illegal to film somebody in a public place.
Yes, sir.
Those are the questions I have at this time.
Okay. It looks like somebody is logging on. I don't know if this is Officer Tate, but just for the purposes of this warrant only, 2022 WA 08116. I do have questions. As I understand the sexual battery statute, there has to be contact with an intimate body part, which the behind would count as an intimate body part for the purpose of satisfying either yourself sexually or the other person sexually. The thing that I want to have the discussion about is whether the alleged spraying, because my understanding is that this was videoed allegedly by Mr. Harris on his phone, and there was store video. And I believe from what I recall, at least from the warrant that I reviewed, is that there was that he had given consent to Officer Tate to review his phone, and that there were several alleged victims, and the victims who were willing to, or alleged victims who are willing to prosecute are the ones that form the basis of the charge. So my narrow question, which I'd like to hear from you, Mr. Little, and you, Ms. Jefferson, is, does the alleged act of spraying whatever onto a body part that would fit within the sexual battery statute, is the spraying sufficient contact for this charge?
Your Honor, if I believe, Attorney Little, you finished all your questions, correct? Your cross-examination questions.
I did. I'm ready to go into argument.
But I do have a follow-up question for the officer.
Okay, and I'm sorry. Go ahead and ask your question.
So the alleged victim in this, Miss Bailey, just a couple of questions. Did you obtain her date of birth or her age?
Yes, ma'am.
And what was that you found out?
I'm going to check right now, ma'am. I don't have access to my laptop right now, ma'am, but I believe that she was around 42 years old.
Okay. And did she give consent?
No, ma'am.
Okay. And you said, I believe you testified that she wrote a statement, and in her statement, she was aware that she was being followed by Mr. Harris, and that she was aware at some point that he sprayed her with lotion. Is that accurate?
Yes, ma'am.
And that area that he sprayed her with lotion was on her butt.
Yes, ma'am. That's correct.
I just wanted to have those follow-up questions, Your Honor. Thank you.
Okay, Mr. Little, do you have any questions based upon what Ms. Jefferson just asked?
I do, Your Honor.
Okay.
Now, Officer Nguyen, when you testified earlier that when you made contact with Miss Bailey, she told you that she wasn't aware that she had been sprayed.
I think I'm sorry, Officer Tate.
Miss Jefferson,
answer the question.
hold on. We'll get the answer. But I do have memory of what I heard, but go ahead.
Your Honor, I was just going to ask Officer Tate to mute his because I'm hearing all of his activity.
Oh, I think it's Officer, yes, Officer Tate. Officer Tate, sir. Can you hear me? Okay, Officer Tate, we're gonna bring you in a second, but I'm gonna mute you because there's some background noise that's coming through, okay?
Oh, yes, Your Honor.
Okay.
Okay.
I'm sorry. Go ahead,
Thank you,
Officer
Your
Nguyen. Thank you.
So, Officer Nguyen, that question was when you first made contact with Miss Bailey, she told you that she was not aware that she had been sprayed. That's correct?
Yes, that's correct. Yeah, my apologies, sir. Yeah, she was unaware that she was sprayed.
Okay, what did officers tell her that she had been sprayed?
The asset protection officer notified her that she's been sprayed.
Okay, but then when you examined her clothing, you didn't see that there was any spray on her.
I didn't examine her clothing, but I didn't notice anything, sir, because I didn't look.
Okay, those are my follow-ups, Your Honor.
Okay, and so Mr. Little, and I'm really trying to get to sort of the heart of the matter, but for the sexual battery charge, the alleged victim doesn't have to know that they've been touched. So whether this person knew that they were touched or not is immaterial to where the touching happened.
Well, I mean, it's not necessarily immaterial to whether or not there was a touching. That's why I asked these questions, to see if there was evidence that the person had in fact had any physical contact. If she's not aware that she was touched and there's no physical evidence on the clothing of any lotion having touched her, maybe she never got touched.
That's possible. I'm taking the evidence as it comes in. This is where I am. is that there's video evidence of an alleged touching. And the alleged touching was by spraying something on the person. So I'm taking that the touching, for purposes of this matter, that the touching that happened was spraying. And that the victim, whether the alleged victim knew that she was sprayed or not, is immaterial to me. The question that I want to hear both of your big, beautiful legal minds help me go through is that, does the spraying amount to a touching that's sufficient under the statute?
And Your Honor, my answer would be yes, because the statute says intentionally makes physical contact with the intimate parts of the body of another without consent of that person. I'm not quite sure where I saw this, when I saw this, but I know I've read some case law where the act of taking a photograph of a woman's undercarriage without her consent also qualifies as sexually inappropriate and sexual battery. Now, I read this case years ago. I couldn't find it right now if my life depended on it, but I'm saying that in the context of the intentional physical conduct that was without consent was the spraying, because he did this with the intention of inappropriately making contact with the woman's behind. She didn't give consent. He's got his camera there. And I don't think that it has to be the situation where he physically touches with his hand. I think the spraying was intentionally done on the behind, and and it made the whatever he sprayed, lotion, whatever kind of material it was, could have certainly evaporated depending upon what her clothing was. But the crux to the evidence that was presented by the officer was that there was video surveillance that was observed of this particular action. So I would argue that the physical spraying, it wasn't like he was in Macy's with the perfume bottles spraying somebody's neck. That's not sexual battery. But this spraying in the particular area that he did on this woman without her consent, I think that amounts to sexual battery.
And where I stand right now on this, Ms. Ferguson, Jesus. How are you, Miss Ferguson?
You've got that just on the brain here, I guess. I don't know. Do I look like a Miss Ferguson? I mean, I'm not ready to change my name to Miss Ferguson, but
No, I apologize. I do apologize because I believe everybody deserves the dignity of being called by their true and correct name. So I don't know why I'm just automatically calling you Miss Ferguson, but Miss Jefferson, where I currently stand on this, and Mr. Little, I mean, it's fair play, and Mr. Harris, you're listening. The alleged conduct is totally deplorable to me, and totally, I could imagine other charges that are being filed. But as a judge, whenever something strikes me that way, I have to pull back, and I have to try to be adherent to the law. And so that's why I'm having this discussion, because emotionally, I would move the case along, but lawfully, I have to be consistent with the law. And I'm gonna listen from Mr. Little, but Miss Jefferson, not Ferguson, you're gonna get the last word. And I don't know why I'm calling you Miss Ferguson, but Mr. Little, you heard from Miss Jefferson. What's your response?
Your Honor, the statute just says what Ms. Jefferson quoted us earlier, which is a person commits the offense of sexual battery when he or she intentionally makes physical contact with the intimate body parts of another person without the consent of that person. It doesn't define what physical contact is. Doing some searching on Westlaw during the hearing, I don't find a case on point that specifically defines what physical contact would be for the purpose of a sexual battery. But I mean, no part of Mr. Harris's body is alleged to have made contact with any part of Miss Bailey's body. So he certainly didn't touch her in such a way that they would have felt each other's bodies making contact in any way. I mean, there may be some case law out there that this sort of attenuated contact could be physical contact for the purpose of the statute, but I don't have a case that says that, Your Honor. So, I mean, reading the law in the light most favorable to not charging people improperly, I would argue that this is not physical contact for the purpose of the sexual battery statute.
And before you respond, Ms. Jefferson, that what Mr. Little just said of the words, 2 words, physical contact, and that's this is in 22 years of practice, this is the first time that I've heard of this as it relates to sexual battery. So I even thought about this one because I think with the one case that I said on first appearance, causing physical contact, does that amount to physical contact? And so if I, which is, I guess I'll use this analogy. If I had a rubber band and, you know, kids, we'd pop the rubber band. So if I sent rubber band across and it made contact in one of the areas that are designed as it relates to the statute, that could amount to physical contact, even though I didn't physically touch the person. I caused the action that led to the touching. So what's your take on that, Ms. Jefferson?
Your Honor, I understand the court's dilemma as it relates to physical contact, and I think we're getting, and unfortunately, there's no time here to do any significant legal research, but I think the physical contact issue can also be understood in the context of transferred intent. The law allows for some inference based on circumstances. So just as, you know, a person could be walking down the street and throwing, you know, an object at someone and they miss and it hits somebody else, you know, that transferred intent, you know, they're still legally responsible for the unintentional harm of another person. But I do think that there is an argument for physical contact, because if, as it relates to the lotion bottle, he had to intentionally push the nozzle, he had to intentionally aim it at her butt, and he had to spray it with the pressing or the pressing of the nozzle to hit her butt. So,
and let me stop you, because I agree with you. I agree with you 100% with what you just said. the like the I mean, I guess it's gonna have to be maybe a test case that goes up for what does physical contact mean. So I'm inclined to send this over and bind this case, this 2022 WA 08116, to bind it over to state court. I think this has to be something that is tested. I know it appears the total bond is right now 45,000. That's something, Mr. Little, maybe you can get Ms. Jefferson and y'all can work out something about lowering the bond, because these are misdemeanor charges. But it's a whole bunch of things I thought in my mind that Mr. Harris could be charged with other than sexual battery. And that was the physical contact thing, was the thing that I was holding on. So Officer Wynn, you can be excused. This case is going to be bound over to the state court of Clayton County. Mr. Little, hold fast. Mr. Harris, hold fast. We have Officer Tate here. Officer Tate, can you unmute yourself, sir? Okay.
Can you hear me?
Yes, sir.
Okay.
So Officer Tate, you're here on two warrants for Mr.
Yes, sir.
Harris. And it's 2022 CW 52294 and 2022 CW 52316. Mr. Harris is here, represented by Mr. Little. Miss Jefferson, definitely not Miss Ferguson, is here representing the state. Miss Jefferson, would you please swear in your witness and begin your examination as to these charges?
Officer Tate, you've already raised your right hand. You're ready to go. Do you swear or affirm the testimony that you're about to give in this proceedings is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Just a quick second before we get into this. Is Mr. Harris still there?
Oh, we need to bring Mr. Harris back.
Oh, wow, we're missing somebody.
Yes, Mr. Harris needs to stay here. He has two more charges. It's just a different officer. Okay, it's just a different officer.
And
Your Honor,
Yes,
to
sir.
give you an update on,
Yeah.
just to give you an update on Miss Alexander, she is being uncooperative. She's not going to be able to come down to the court today.
Okay, and
That's my case, Your Honor, David, sir.
yes. Okay. I know we have an officer standing by. Officer Allen, are you still there?
Yes, sir, I'm here.
Officer Allen, it looks like this case is going to be continued, and I don't want you to be sitting on. Mr. Sugg, what is your response to the request from the jail as to Miss Alexander being uncooperative?
I mean, I can't waive her preliminary hearing without her permission. And I mean, at this point, all I can say is perhaps a continuance would be best. Give me a chance to try to meet with her again this coming week and try to get to the bottom of what's going on, or what went on today. Because I have spoken with her previously, and our plan was to proceed with the prelim.
Okay, and so I'm taking what the jail is informing me as being true. We can proceed today because a person, although they have the right to appear at a hearing, if through their behavior they absent themselves from the hearing, let's say we'll use trial, for example, that the trial still goes on without that person being present. And it's a heavy thing for a judge to do. And I'm not inclined to do it. I'd rather continue the case so that she can be present and hear everything that's going on.
I mean, just to say, the last time it was reset due to the officer being unavailable. This time it looks like the client is unavailable. So I guess we're 1 for 1, perhaps holding off and making that move until next week, give her one more chance. Because like I said, per my last conversation with her, she wanted to proceed with the prelim. So
I understand. Ms. Jefferson, what's your position on this?
Your Honor, the state doesn't have an objection to resetting this due to the circumstances today. But Officer Allen is here for another case as well. He's here for position number, I don't know what the position number is. Position number 17, Mr. LeMay.
Okay. Which should be a felony.
It's looking a little suspicious.
Yeah. I can't imagine that these two incidents didn't take place at the same time. And I know because the warrant numbers are 6-4 and 6-5. Which would tell me that they were written at the same time. So I think this is going to have to go over to felonies. And I've made the mistake before, but
Mr. Tatro.
Yeah, I think what I'm going to do is I'm going to continue this case and place it on the felony calendar. So
I'm sorry, Your Honor, you said you were going to continue the
LeMay.
Yes.
And place on the felony. I'm also going to continue Miss Alexander's case and place that on another misdemeanor calendar. She's charged with simple battery. Looks like it says she has a $4,000 bond. I don't know the circumstances behind the charge, but it would seem to me that something possibly can get worked out and her case can get bound over to state court. But Mr. Sull, you said you wanted a hearing, and that's your client's right. So, Miss Mary, do we have a new court date for the misdemeanor cases?
Misdemeanor, we're gonna move to June 8th.
June 8th. Okay.
That's the right date. Hold on. I'm sorry, June 7th.
June 7th. Okay, we're going to continue this case to June 7th to allow Mr. Sull to be able to speak to his client.
Yes, Your Honor.
So let's go back to Mr. Harris. And I interrupted you, Miss Jefferson. So I think we've sworn in Officer Tate, so we can move forward.
Yes, sir. Being that I don't really remember what I had asked other than swearing you in, I'm going to ask you to state your name and where you're employed.
My name is Detective M. Tate. I'm employed with the Morrow Police Department.
And were you so employed on Friday, March 4th, 2022?
Yes, ma'am.
And on that day, did you respond to an incident or an incident at the Walmart?
Yes, I did.
And tell me where the Walmart is located.
6065 Jonesboro Road, Clayton County, Morrow, Georgia.
Thank you. And the basis for responding to the incident and the issuance of the charge of sexual battery against Mr. Harris, can you tell us what that's about?
Yes, ma'am. The reason I responded over there with Officer Winter and Lieutenant Beard was because I was already working an investigation involving a sexual battery that took place at Walmart. So when I get over there, I looked at video footage. I met with loss prevention, the two officers involved, and Mr. Harris. I looked at video footage which matched the same person that committed the offense on the other prior to that day.
So you were over there and you saw video surveillance from another date as well? Is that my understanding?
Yes, ma'am. It's two other incidents involving Mr. Harris. I went over there and I spoke with Lieutenant Beard, also Wynn, and Loss Prevention, and they put a video, Loss Prevention put a video of Mr. Harris being inside that location on the other 2 days prior to that date that he was arrested.
And the video that you saw, what did you actually see, or what did you find out what actually occurred?
Well, I don't have the reports in front of me, but I'm testifying from memory. But however, one of the victims, you see Mr. Harris following her around. I didn't see him spray it on her, but she said he did, and she wrote a statement saying he did. And the other was the same thing. I didn't see him spray it on her, but they both wrote the same statements, identified that person as being the description fit what they gave.
And these were two. Sorry, go ahead. Sorry.
The video footage from both incidents matched Mr. Harris.
And the video that you saw, can you be more specific as to what you saw in that video?
Well, one of the victims, he was hanging around with her, following around. Oh, and he had the spray bottle in his hand with his cell phone. And he was following around the store, but she got out of camera range when it came to the spraying part. I didn't see him spray it on her, but they had the lotion in his hand, and he had the video for his phone in his hand, recording it.
So for the two separate individuals, you said that you saw the video of him following, but you didn't see the spraying on one, but you saw it on the other?
No, I didn't see the spraying on either one of them.
Okay. But those two individuals, they both did written statements regarding what they experienced.
Yes, ma'am.
Okay. Did you speak to, sorry, go ahead.
One other thing, when Mr. Harris was in the office, the loss prevention office, Lieutenant Bill Mirandized him. He said he didn't want to talk. However, once he said he didn't want to talk, we didn't ask him any more questions, but he started spontaneously make utterance. So he was Mirandized again. He wished to talk. He said that he gets paid from different males to do this, to go spray it on their butts and record it. He also opened up his phone and showed evidence to what he had just said. He showed evidence that he was doing it. And he also showed another video where he's walking around with an erection in the store. He has his penis out.
I think I'll stop there for now.
Mr. Little.
Thank you, Your Honor. Officer Tate, so the warrants you requested, these CW warrants, they were based on surveillance footage you saw from the Walmart?
Surveillance footage and the statement from the victims.
What dates were those incidents on?
To be honest with you, sir, I don't have the reports in front of me because I didn't know I was going to be appearing on Zoom today, so I'm not even in my office.
Were these Were these all at the Morrow Walmart?
Yes, sir. Both incidents took place at Morrow Walmart. And there's also some other victims that might come forward, some employees, because the employees of Walmart advised loss prevention that he did it to them too, but they haven't came forward as far as like doing anything with the case.
Okay. Do you know the names of the alleged victims in these cases?
No, sir.
Okay. But you were able to make contact with them?
You talking about the ones that haven't filed a report yet?
No, I meant the alleged victims for the 2 warrants we got, the CW warrants you requested.
Yeah, I spoke with one of the victims over the phone. Well, I went to her office, as a matter of fact. I went to a business. She's a business owner in the city of Morrow, and I went and spoke to her and asked her what happened. She told me that he sprayed it with some kind of substance. She could tell me what it was, and she wanted to file charges against him.
How were you able to identify her? How were you able to find her?
Oh, by the report. Her name was on the report, and I took that and I went to the address.
Oh, okay. So did another officer make a report first? You were not the initial investigating officer on this?
Right. Another officer made a report. I was assigned to investigate the case.
Okay, that makes sense. Those are the questions I have.
Okay, Ms. Jefferson, any follow-up?
At any time, was there, with the 2 victims with these 2 particular warrants, did they give consent to the spraying of whatever was sprayed on their butt?
No, ma'am.
Were either of the women under the age of 16?
No, ma'am. They were full-grown adults.
Thank you. That's all I have. The state rests.
Any recross, Mr. Little?
No, Your Honor.
Okay. May Officer Tate be excused?
Yes, Your Honor, the state would submit.
Okay. Officer Tate, sir, thank you for coming on. You can be excused or you can stay on. It's your choice. Mr. Little, do you have any argument?
I do, Your Honor. As to these 2 warrants, I would allege the states failed to meet their burden of probable cause. We don't know when these are alleged to have happened. We don't know who the alleged victims are, Your Honor. We don't have enough specificity to know that there was probable cause for these specific allegations that Mr. Harris is charged with. We've heard testimony that there were some women on some dates that may have been touched by some substance, but we don't have enough specificity to meet the burden of probable cause for criminal warrants.
Okay. Jefferson, do you have any response to that?
Yes, Your Honor. The officer did testify to the dates. I believe I asked him the date with which he went to the Walmart and saw the video and conducted his investigation. And the testimony that he provided corroborated essentially what the allegation was regarding the spraying of a substance on non-consenting women's butts on video. And there were some additional statements that the defendant or to-be defendant said, admitting to the actions that he had taken. And there were also, I believe, testimony regarding written statements by the 2 women to support the charges or the warrants that were taken out.
That comports with, I believe, what I heard. So I'm going to bind these charges over to Clayton County State Court. I don't know, Mr. Little, if there are more charges that may come for your client based upon these alleged actions. But if there are videos, it could be a lot. Okay, Officer Tate, Sir, you can be excused. This case is going to get bound over to the state court, Clayton County. Are we at a point now where I can switch over for the lawyers to meet with their clients over at the jail? Mr. Harris can be excused. And I'm just asking because I know we have a few officers, but I believe those are cases where the lawyer is going to have to speak to their clients before we know what we're going to do on those cases. So I'm just asking everyone involved.
Your Honor, I believe Officer Kilgore is here for Jackie Fleming.
Was Fleming one of the cases where the lawyer needed to speak?
She is.
That I'm not sure.
Yes,
Yeah, Mr. Little needs to pre-trial or have a pre-trial discussion with his client. So we have Rashad Battle, and it's an Officer Loudon. And I think Officer Loudon is on a couple cases, but Officer Loudon has not appeared. I am going to be inclined to dismiss those cases if Officer Loudon is not here. But what I'll do, I'm gonna let the lawyers, Mr. Sub, Mr. Little, Mr. Lane, enter into breakout room. I'm gonna allow you that time, Ms. Ferguson, to try to, I just did it again. I don't know why I'm calling you Miss Ferguson. We'll blame it on my bad eyesight.
Okay.
But I'm gonna be thinking about this all night. Why am I calling Miss Jefferson Miss Ferguson? I do not know why yet, but I'm gonna try to figure it out. And so, Miss Jefferson, my approach, basically, like I said, I've been a lawyer for 22 years. Now I've been before judges that are mean and nasty and all of that kind of stuff. I do not try to be mean nor nasty. I listen to everyone and I tell everyone what I'm thinking so that we can hopefully have a fair and honest airing of the facts as most as possible. So I don't know why, ma'am, that I am calling you Miss Ferguson. I need to maybe I need to go sit on a couch somewhere and psychiatrists tell me why I'm so infatuated with the name Ferguson. But I don't know, but I do apologize. And I don't know why I keep doing it. So, Mr. Little, Mr. Lane, Mr. Suh, I'm going to place you in breakout room 2 at the jail. It looks like Ms. Bellow was able to work out whatever going on with Ms. Pass. So I don't believe there's anybody that you have to speak to right now. Maybe when these 3 gentlemen come out, and maybe some other further discussion, and that is what I'll allow. But I'm gonna place you all in that breakout room now, and we'll see where we're going. All right, Mr. Sun, Mr. Little, Mr. Lane. what you all don't know is my eyesight is so poor that my the font on my computer is so big that probably can fit like 3 words in it before I have to scroll down. All right, let's see. All right, Mr. Lane, I just found you. Okay, you 3 should be able to go into your breakout rooms now, and I will stand by. And Miss Jefferson, you can take a break until we hear from those 3 gentlemen.
Your Honor, it looks like we need the jail with us.
Yes, I just realized that. I just placed them over in breakout room 2.
Perfect. Thank you, sir.
Okay.
Your Honor, if I may address the court.
Yes, Mr. Suh.
Your Honor, I was hoping to speak with the solicitor that will be handling Keenan Myrick's case to try to find a resolution for today. Keenan Myrick's case.
Okay, Ms. Jefferson, you're gonna handle that?
Yes,
Okay, I'm gonna place you and Mr. Suh in breakout room number 3.
okay.
Sounds good.
Okay. Ms. Jefferson, you should receive the link now to go into breakout room 3 with Mr. Suh.